Aaron Spencer's gag order is lifted by Arkansas Supreme Court. Aaron Spencer's case began to become more publicized as the Supreme Court of Arkansas said that the gag order against Aaron Spencer and all involved was seemingly unconstitutional, and this is a case that needed to be in the eyes of the public, that this is not how we do things. And it actually ended up growing the support of Aaron Spencer, a father who killed his minor daughter's PDF file, predator, whatever you want to call it, in the midst of this predator kidnapping his minor daughter and had already taken off with her while the father arrived. So let's take a look at what the Arkansas Supreme Court has to say about the judge silencing everyone and trying to keep this case hush hush. Aaron Spencer versus the state of Arkansas. This is from the Supreme Court of Arkansas, and the opinion delivered was May 29th, 2025. Petition for writ of certiorari to the Lonoke County Circuit Court with the case number. Honorable Barbara Elmore is the judge. Petition for writ of certiorari granted. Writ issued. Circuit Court's gag order vacated. So, the Supreme Court of Arkansas overturned or vacated the order that the Superior Court had tried to do. The Superior Court said, no, this is not how we do things. So, Courtney Ray Hudson is the associate judge that I'm guessing is writing this, and Barbara Elmore is the judge that tried to keep this hush-hush. So it says, Aaron Spencer has filed a petition of writ for certiorari requesting that a gag order entered in his Lonoke County Circuit Court criminal case be vacated. He argues that the entry of the gag order was a plain, manifest, clear, and gross abuse of discretion, and that there is no other adequate remedy but for the writ. We agree, and we grant the petition of writ for the certiorari and vacate the Circuit Court's gag order. And they're going to give us some background, and then they're going to tell us what they really think. So the background. On November 27, 2024, Spencer was charged by felony information with second-degree murder, along with a firearm enhancement under Arkansas Code, anointed Section 1690-120, for the shooting death of a 67-year-old Michael Fossler. That is the predator involved in this case. The state alleged that on October 8, 2024, so a year ago, Spencer knowingly caused Fossler's death under circumstances manifesting extreme indifference of the value of human life. I'm sorry, what? We're talking about a PDF file here. They are indifferent to the value of human life, in my opinion. Which is a Class A felony under Arkansas Code, anointed Sections 510-103. The circumstances of the shooting were as follows. In July of 2024, Fossler had been charged with numerous sexual offenses against Spencer's teenage daughter, and he was released on bond. On the night of the shooting, Spencer awoke to his dog barking and realized that his daughter was gone. Spencer found a hoodie on a stuffed animal placed in her bed. As a result, he left in his truck to search for her. This is at 1 a.m. in the morning. They don't say that here, but it's about 1 a.m. when this happens. Spencer located Fossler's truck with his daughter inside, and he forced Fossler's truck off the highway. After an altercation, Spencer called 911 to report that he had shot Fossler. Fossler died at the scene. On December 4, 2024, the state filed a motion for a gag order alleging that Spencer's arrest had garnered media coverage throughout the state and the nation. Boo-hoo. Stop doing things that you don't want people to know about. Well, I didn't want people to know that we were doing things that aren't right. I didn't want people to know that I was committing crimes. Well, then stop being dumbasses. Attached to the motion was a press release from Spencer's attorney, Aaron Casanelli, and Michael Kaiser, criticizing the decision to charge Spencer criminally as targeting a heroic father. The state also pointed to a television interview in which the defense counsel allegedly stated that they felt confident that the community would side with Spencer because every one of them would have done the same thing for their child or their neighbor's child or member of their family. Yeah, probably. So, I mean, his daughter was in danger, imminent danger at that point. The state argued that a gag order was necessary to preserve the integrity of the jury pool and to ensure the right of a fair trial for both the state and the defendant. The state proposed 8 content-based limitations on speech of any party. Any attorney or agency connected with this case, directly or indirectly, any judicial employee or officer of the court, any public official now holding office, including but not limited to law enforcement officials, their agents, deputies, or employees, and any person subpoenaed to testify in the trial of this case. That's where you fucked up, Judge. Because you can tell the lawyers to shut their traps and do not talk about this. You cannot tell people, the public as a whole, that they cannot talk. Like, they're allowed to talk, because why are they being punished because they know somebody in a case? That's ridiculous. You don't punish people who've done nothing. On December 9, 2024, Spencer filed a detailed response in opposition to the motion for gag order. He argued that granting the motion for a gag order would violate his due process rights to a fair and public trial pursuant to the 6th and the 14th Amendment, as well as the First Amendment right to speak pursuant to both the Arkansas and United States constitutions. Spencer requested that a hearing on the state's motion be held in open court. Yeah, they don't want nothing in open court. On December 10, 2024, without holding a hearing, the circuit court entered the order at issue, noting that apparent public interest in this case and the resulting extensive news media coverage, the court granted the state's motion with some modifications. As grounds for the entry of the order, the court stated, "It appears to the court that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial." The court further noted it was seeking a fair balance between constitutional guarantees of a free press. The order implemented the 8 public prohibitions requested by the state. So I can tell you right now, this will probably not be a live stream trial, because it is the judge who gets to decide if media is allowed, and this judge is not going to allow it. Even though this gag order was lifted, she doesn't have to agree for media coverage, so this would be a trial that someone would have to go sit in. So it says, "It is ordered of this court that no party to this action, nor any attorney or agency connected with this case, directly or indirectly, non-judicial employee or the officer of the court, no public officials holding office, holding not limited to law enforcement officials, any agents, deputy employee, and such, and no person subpoenaed to testify at the trial of this case. Either shall the defendant nor his family shall do any of the following. So, even family members, like if Aaron Spencer's sibling wanted to speak out, who has nothing to do with this case, like they weren't there, they wouldn't be a witness or anything, they're just a family member, they are not allowed to talk about what is happening to a sibling. Or a grandmother is not allowed to speak about a grandson. His parents are not allowed to speak. I mean, obviously his wife and his child aren't allowed to speak, but they would be witnesses in the case. But people that are not party to this case, and then subpoenaed. How do you know if you're going to be subpoenaed? Can you talk before you're subpoenaed? Or no? Like, this is unconstitutional. You cannot do this. And why would you want to do this, state? It's because you know you're overcharging, you're doing too much in this. And you don't like that the public is not on your side. It says 1, release or authority or authorize the release of public dissemination of any purported extrajudicial statement of the defendant relating to this case. Okay, the footnote 1 is the order included several notations handwritten and initialed by the judge, including the addition of the Spencer's family. Number 2, release or authorize the release of any documents or exhibits or any evidence, the admissibility of which may have to be determined by the court. 3, make any statement for public dissemination as to the existence or possible existence of any document, exhibit, or any other evidence. Express outside of the court an opinion or make any comment for public dissemination as to the weight, value, or effect of any evidence as tending to establish guilt or innocence of a defendant. Make any statement outside of court for public dissemination as to the weight, value, or effect of any testimony that has been given. 6, issue any statement for public dissemination as to the identity of any prospective witness or their probable testimony or effect thereof. 7, make any out-of-court statement for the public dissemination as to the weight, value, source, or effect of purported evidence alleged to have been accumulated as a result of the investigation of this matter. 8, make any statement for public dissemination as to the content, nature, substance, or effect of any testimony which may be given at any proceeding related to this matter with an attorney of record or any agent thereof. This order does not include factual statements of the defendant's name, age, residence, occupation, or family status. The circumstances of the arrest, namely the time and the place of the arrest, the identity of the arresting and the investigating officers and agencies, and length of the investigation. The nature, substance, and text of the charge, including a brief description of the offense charged. See, that to me, that's allowed to be out there, but his defense in saying he is not guilty of these charges is not allowed to be out there. The public can see what he's charged of, but the public may not see him say he is innocent. That is not allowed, is what this judge says, basically. Quotations from any or any reference without comment to public record of the court in this case, or to other public records or communications heretofore disseminate to the public. So those are things that are not included in the order. 5, the scheduling and result of any stage of the judicial proceeding held in open court or in an open public session. 6, any request for assistance in obtaining evidence. 7, discussion by any witness or prospective witness of any matter in connection with the case with any of the attorneys representing the defendant or the state. All parties and the defendant are under a gag order. Gag order, not ORI. So basically, everybody needs to shut up and not ever mention this case. The order goes on to require 1, that a copy of the order be attached to any subpoena served on any witness in this matter, and 2, redaction of any information violating the gag order from any paperwork related to the case that might be disseminated to the public. The order further states that it will be forced until the case has been disposed of or until this court orders otherwise. The order will help ensure all parties get a fair trial. Finally, the order provides that the entire case is now sealed. Because of this order, it is not sealed, and that is why we have documents, because they were all sealed and nobody could get these documents. But because the Arkansas Supreme Court said, I don't think so, they're public, publish them. Thus, the Circuit Court adopted that the request prohibitions contained in the state's motion for a gag order with the qualifications listed in the provisions 1 through 7 and the sua sponte sealing of the entire case, see footnote 2. We note that this order is nearly identical to the orders we vacated without written opinion in Arkansas Democrat Gazette Incorporated versus State of Arkansas. Petition for writ of certiorari granted. Although the present order does not expressly apply to media outlets, the 8 prohibitions on speech and the 7 provisions for information not prohibited by the order use the same language as in the Arkansas Democrat Gazette gag orders, styled orders regarding publicity. Arkansas courts shall no longer use this apparent form order. Okay. On February 2nd, 2025, Spencer filed in this court a petition for writ of certiorari and for other relief. The state filed a response on February 2nd, and Spencer later filed a motion to stay proceeding in the circuit court. Take the petition as a case and set a briefing schedule pursuant to Arkansas Supreme Court Rules 61F, filing briefs and petitions for extraordinary writs. Spencer also requested oral argument. We granted Spencer's motion to stay proceedings in the circuit court, took the petition of the writ of certiorari a case, set a briefing schedule, and granted Spencer's request for oral arguments. The petition is now ripe for decision. Standing for issue of writ of certiorari. I am not going to get that word right. A writ of certiorari is an extraordinary relief. They cite a case. 2 requirements must be satisfied in order for this court to grant a writ of certiorari. All right, we're going to figure out how to say this word because okay, cert. Okay. certiorari, okay? That's what that says. Certiorari lies only when, 1, it is apparent on face of the record that there has been a plain, manifest, clear, and gross abuse of discretion, or 2, there is a lack of jurisdiction, an act in excess of jurisdiction on the face of the record, or the proceedings are erroneous on the face of the record. Second, there can be no other adequate remedy but for the writ of certiorari. This court has held that a writ of certiorari, what do they have to write that word so many dang times? Is the appropriate remedy when a prior restraint on speech is plain, manifest, clear, and gross abuse of discretion. And then they cite some case. The analysis. Spencer argues that the gag order violates the First Amendment because it is an unjustified prior restriction on certain content-based categories of speech. He further argues that the circuit court exceeded its jurisdiction when it placed the overbroad restrictions on the speech of non-parties without due process. Exactly. Like the people of the public and family members not related to this case, they have no due process when they're told that they can't talk about something. The state responded with the circuit court's order was within constitutional limits, protects the integrity of the case, and ensures a fair trial for both Spencer and the state. I don't care why? All of a sudden, or all these states saying we deserve a fair trial too. You're the state. Nobody's doing anything to you, but you do not have a constitutional right to a fair trial. The defendant does. But this has been a huge thing that people keep saying lately, is that the state deserves a fair trial. The Commonwealth deserves a fair trial. It goes on to say, for that reason that follow, we hold that the circuit court's action in entering the challenged gag order was on its face a plain, manifest, clear, and gross abuse of discretion and in excess of its authority. Further, there is no other adequate remedy except for a writ of certiorari. Standing. As an initial matter, we must address the state's argument in its response brief that Spencer lacks standing to challenge the order based on the constitutional rights of others. Indeed, as a general matter, constitutional rights are personal rights and may not be raised by third party. However, the issues raised in this petition for extraordinary writ require us to consider restrictions not directed towards Spencer personally, and we decline to uphold any part of the order in light of the order's clear lack of evidentiary basis as a whole. Here, the circuit court's order is extremely broad as to the persons restrained from speaking. It restrains the parties, their attorneys, any public officials now holding office, along with their staff, witnesses, court staff, and the defendant's family. The order is extremely restrictive as to what information is being shielded from public view. It restricts filings and perhaps courtroom proceedings from public view. The order implicates Spencer's right to public trial as well as the public's right to know how officials are conducting their criminal proceedings. Correct. We have a right to know if the state is doing their job, if the judges are doing their jobs. And if this judge is an elected judge, I don't know if the next time there's an election, this judge will get to stay on the bench. Or if they're like Massachusetts and they're just appointed and there are no elections, which is horrible. You have the right to know what is going on where you live and what the government is doing. If they're doing their job, great. If they're not, changes need to happen. And I get that some people do not like that there is now a tension where they could do secretive, shady stuff before. And the ones that were doing things correct anyways, they don't care because they're not doing shady shit. You want to keep things in the dark because you know you're doing things wrong. Y'all are not there for the right reasons, which is to seek the truth. All right. The state points out that Spencer raises arguments regarding the gag order's application to public officials and to his family, the restrictions on public and press access to the court file, and the due process rights of non-parties as to entry of the order without notice. However, Spencer clearly has standing to bring this petition requesting that this court vacate the gag order in this criminal case, and we will address Spencer's arguments to the extent necessary to resolve the issue raised in this petition. Freedom of speech. Listen up. There's a few lawyers that I know that really need to listen up to. The First Amendment to the United States Constitution provides in part, Congress shall make no law abridging the freedom of speech. The First Amendment is made applicable to the states by the 14th Amendment. Similarly, Article 2, Section 6 of the Arkansas Constitution provides, the free communication of thoughts and opinions is one of the invaluable rights of a man, and all persons may freely write and publish their sentiments on all subjects. Spencer relies on both the United States Constitution and the Arkansas Constitution in arguing that the gag order in this case violates his and others' free speech rights. However, free speech rights are not absolute, and in rare cases must yield to the Sixth Amendment's guarantee of a fair trial by an impartial jury. They cite a case discussing the Sixth Amendment's guarantee of a fair trial by an impartial jury as a basic requirement of due process. A gag order is defined as a judge's order directing parties, attorneys, witnesses, or journalists to refrain from publicly discussing the facts of a case. Then they cite to Black Law's Dictionary. Thus, a gag order is, by definition, a prior restraint on speech. Prior restraints on speech and publication are the most serious and the least tolerable infringement of First Amendment rights. As such, a prior restraint on speech bears a heavy presumption against its constitutional validity. Citing Helena Daly, World versus Symes in 2006. In fact, the Supreme Court has recognized that the criticisms of the state lie at the very center of the First Amendment. This could include speech critical of judges, prosecutors, public defenders, and law enforcement. See Gentile versus State Bar of Nevada, 1991 case. It would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which criminal trials are conducted. Quoting Richmond Newspaper Incorporated versus Virginia, a 1980 case. Yeah, because if for some reason we get arrested or somebody we know gets arrested, we need to know that things are going to be done constitutionally. We need to make sure that the people that we put in power are representing the community's best interest. And if they're not, we need people in there that are going to. We cannot allow these people on power trips in there. We need people that want to work for the people and make the places better. The Supreme Court of the United States has only directly addressed the constitutionality of gag orders as they apply to the press, not as attorneys, parties, witnesses, or the public, nor has the Supreme Court articulated a legal standard for when, if at all, such prior restraints would be permissible. In Nebraska Press, the court considered gag orders on the press and strongly disapproved of such prior restraint except in extraordinary circumstances. The court noted that pretrial publicity, even if pervasive and concentrated, cannot be regarded as leading automatically and in every kind of criminal case to an unfair trial. The court stated that it was required to determine whether the gravity of evil, discounted by its improbability, justifies such invasion of free speech as it is necessary to avoid the danger. To do so, the court examined the evidence before the trial judge when the order was entered to determine the nature and extent of pretrial news coverage, whether other measures would be likely to mitigate the effects of unrestrained pretrial publicity. However, effectively, a restraining order would operate to prevent the threatened danger, and whether the precise terms of the restraint orders were too broad or too vague. In Gentile versus the State Bar of Nevada, the court considered the circumstances under which the attorneys may be punished after speaking. The court upheld prohibition on speech that presents a substantial likelihood of materially prejudicing an adjudicatory proceeding, as provided for in Nevada's professional conduct rules. Importantly, the Supreme Court held that the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than that established for regulation of the press in the Nebraska Press case. Nebraska Press and Gentile provide guidance but do not answer the question whether or when gag orders may be placed on attorneys, parties, witnesses, or the other public in pending cases. Here, the gag order was intended to address the need to protect the integrity of the jury pool, to ensure that all parties get a fair trial, in light of pretrial publicity. When considering pretrial publicity, a trial court has the difficult job of balancing constitutional interests while upholding its affirmative duty to protect the integrity of the criminal justice process. The Supreme Court made this clear in Shepard v. Maxwell, a 1966 case, when it granted habeas relief to a petitioner who had been deprived a fair trial in his state murder conviction because of the trial judge's failure to protect him from massive, pervasive, and prejudicial publicity and from the carnival atmosphere at the trial itself. The Shepard court noted that the trial court might well have proscribed extrajudicial statements by any lawyer, party, witness, or the court official which divulge prejudicial matters. We recognize that Shepard was an extreme case in which there was no doubt that the deluge of publicity reached at least some of the jury. The court ultimately concluded that Shepard had not received a fair trial consistent with the Due Process Clause of the 14th Amendment and reversed his conviction. While intense publicity can prejudice a trial, we note that an impartial jury need not be woefully unaware of information, including potentially prejudicial information outside of the record. That is in Murphy Brown, LLC, Fourth Circuit case from 2018. We now turn to the arguments regarding which standard should apply to a prior restraint on speech in the context of this case. To justify a prior restraint on free speech, there must first be a factual showing of necessity. In other words, this court must determine whether the circuit court's order is justified by a sufficient risk of material prejudice to an ongoing judicial proceeding. This court has explained, the question becomes whether the justification for the restraining order are sufficient weight to eclipse the substantial weight of the interests protected by the First Amendment, which dictate the heavy presumption against the constitutional validity of prior restraint. Helena Daily World. See also Nebraska Press. Supra, discussing tests for justification of invasion of free speech rights. What then is necessary showing? Spencer argues that a gag order is permissible only under the highest level of scrutiny. That is, if there is a serious and imminent threat to the administration of criminal justice. In contrast, the state relies on Gentile and argues in favor of a heightened standard that is less rigorous than strict scrutiny. In the absence of Supreme Court precedents, the federal circuits and states have taken different approaches to gag orders. Some courts have adopted the clear and present danger or serious and imminent threat standard. United States versus Ford, a Sixth Circuit 1987 case, requiring a serious and imminent threat to restrain the speech of a criminal defendant. Levine versus United States District Court, a Ninth Circuit 1985 case, requiring either a clear and present danger or a serious and imminent threat for a prior restraint on attorney speech. Chicago Council of Lawyers versus Bauer, it's a Seventh Circuit case from 1975, applying serious and imminent threat standard. United States versus Trump, D.C. Circuit Court 2023, we hold that some aspects of the defendant's speech pose a significant and imminent risk to the fair and orderly adjudication of criminal proceeding, which justified protective action by the direct district court. Brenier versus Takio, 1992, extrajudicial statements of attorneys may be subject to prior restraint by a trial court upon a demonstration that the activity restrained poses a serious and imminent threat to the defendant's right to the fair trial and to the fair administration of justice. Emphasis added, and then they cite more case, adopting clear and present danger or serious and imminent threats standard for issuing a gag order in a civil case. Other courts have adopted the substantial likelihood of the material prejudice standard. Citing more cases, still other courts have adopted a reasonable likelihood or a prejudice standard. Before entering a gag order restraining trial participants, the court must first determine whether there is a reasonable likelihood that pretrial publicity will prejudice the defendant's right to a fair trial. I don't think this would prejudice the defendant because he's not the one asking for it. It prejudices the state because the state does not think that people will side with them if they know the truth. Well, then you probably shouldn't have brought the case. When determining which standard to apply, we must initially recognize whose speech is being restricted. We can identify three categories of persons potentially subjected to gag orders: attorneys of record, non-attorney trial participants, such as a criminal defendant, witnesses, and court staff, and 3, the public at large, i.e. those who are not participating in the trial. See footnote 3. We do not address gag orders on the press in this opinion because the order before it does not impose restrictions on the press, nor does any member of the press challenge it. We note that this court has previously addressed gag orders placing prohibitions on the press in Arkansas Democrat Gazette versus Zimmerman, which is a 2000 case. Because the gag order entered here, including members of all three categories, we review each to establish the appropriate standards. And the reason I think that this gag order didn't address the press being quiet is because there is nothing for the press to report if everybody else has to be quiet. There should be no information for the press to put out there because nobody is to be talking. First, we address attorney speech. The Supreme Court has recognized that speech by the attorney is subject to greater regulation than speech by others. The court recognized that the states have historically regulated admissions to the bar and exercised authority to discipline attorneys have access to non-public information and are viewed as authoritative, both of which pose a greater potential risk to the fairness of a trial, and attorneys are officers of the court. For these same reasons, we find it appropriate to allow greater regulation of attorney speech in the context of a criminal trial than would be permissible for the speech of non-attorney trial participants or members of the public. Thus, we hold that attorneys in Arkansas may be restricted from extrajudicial speech that poses a substantial likelihood of material prejudice to an ongoing criminal proceeding. This is consistent with attorneys' existing obligation under Rule 3.6 of the Arkansas Rules of Professional Conduct regarding trial publicity. So, if you watched Karen Reed or followed that, you will notice that there was a gag order put in place for the attorneys. And so you will note that after a certain point when that gag order was put in place, Karen Reed was the only one that could say something about her case. Her attorneys, nor the prosecutors, could speak about it. And so sometimes you tell your client as well, okay, I'm not allowed to talk, but you don't need to be talking about this case either, because anything you say can and will be used against you. And so if you say something, the prosecutors of the state, the Commonwealth, whoever is charging you, will try to twist that to make it fit for their theory. And so in that case, a lot of times nobody ends up talking about the case if the attorney cannot be the one speaking about it and advocating to people. All right. Next, we consider the free speech rights of non-attorney trial participants. These persons are not subject to the same rules and restrictions as attorneys. But as participants in the trial, their speech has the potential to have a greater impact than the speech of non-trial participants. C. Shepard. Neither prosecutors, counsel for defense, the accused witnesses, court staff, nor enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. Thus, we conclude that free speech protections for non-attorney trial participants are greater than those of the attorneys of record, but less than those of the public at large. Therefore, we hold that the speech of a non-attorney trial participant may be restrained only to the extent that it poses a serious, imminent threat of material prejudice to an ongoing criminal proceeding. Finally, we address prior restraints on the public, whose speech is afforded the most protection in the context of a gag order. So okay. Restraining the speech of the public raises obvious issues regarding lack of due process. We cannot fathom why the circuit court believed it could prohibit the speech of any public official now holding office. In fact, it is difficult to foresee any circumstance in which a prior restraint on the speech of a member of the public, which would include a public official, could be constitutional. Like, they do not know where in the world this judge thought that she had the authority, discretion, whatever, to do this. She was on a power trip, and the Arkansas Supreme Court was like, absolutely not. Like, I don't know who you think you are, but no, this is not how we do things here in the United States or Arkansas. Having established the legal standard to be applied, we turned to the additional findings a circuit court must make in every case to justify the entry of a gag order restricting the speech of any individual. First, the circuit court must determine whether alternative measures would protect the party's right to a fair trial. See Nebraska Press, Supra. Here, Spencer suggests that the extensive voir dire of prospective juries or jurors using an expanded jury pool, giving cautionary instructions, changing venue, or postponing the trial are alternatives that should be considered before restraining speech. But the circuit court heard no evidence and made no findings in this regard. In addition, the circuit court must find that a gag order would be likely to accomplish the goal of preventing prejudice to their proceedings. See Nebraska Press, Supra. Again, there was no such finding in this case. Finally, a gag order must be narrowly tailored to prohibit only what is necessary to protect the integrity of ongoing judicial proceedings, e.g., Gentile. In other words, the restrictions imposed must not be overly broad. Here, many of the prohibitions on speech listed in the gag order were overly broad. For example, prohibiting the public expression of an opinion as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendant by the public official is clearly overbroad. In sum, before entering a gag order, the circuit court must specifically find, based on evidence in the record, that 1. The prospectively limited speech would pose a sufficient threat of material prejudice to an ongoing criminal proceeding, depending on whether the limitation applies to attorneys of record, non-attorney trial participants, or members of the public. 2. After consideration of alternative, less restrictive measures, none would sufficiently protect the party's right to a fair trial. 3. The prohibitions would likely to prevent material prejudice to the proceedings. And 4. The prohibitions are narrowly tailored to prohibit only what is necessary to prevent material prejudice to the ongoing proceedings. Due process, vagueness, and overbreadth. Spencer also argues that the order is impermissibly vague and that it is impossible to know what is covered by some of its provisions. He states that it is unclear, for example, whether statements on social media are restricted or must be removed, whether previous public filings now removed from the public access may be shared, what for public dissemination means, and precisely who this gag order restrains. Spencer also argues that it is unclear what exactly prohibition number 8 seeks to restrict. According to the provision, the named individuals cannot make any statement for public dissemination as to the content, nature, substance, or effect of any testimony which may be given at any proceeding related to this matter with an attorney of record or any agent thereof. The state, of course, maintains that the gag order is not unconstitutionally vague. The void for vagueness doctrine addresses at least 2 connected but discrete due process concerns. Regulated parties should know what is required of them, so they may act accordingly. And precision and guidance are necessary, so that those enforcing the law do not act as an arbitrary or discriminatory way. FCC versus Fox Television Stations Incorporated, 2012 case. Stated differently, the prohibition against vague regulations of speech is based in part on the need to eliminate the impermissible risk of discriminatory enforcement, Gentile. Vague prohibitions also create a chilling effect on speech because one does not know precisely what speech is prohibited. Here, we agree that the gag order is unconstitutionally vague and must be vacated. For example, who is included as a part of Spencer's family? Does this purport to restrain the speech of his second cousin or only that of his parents, spouse, and children. Right. That's what I said. Due process requires more specificity. In his petition for the writ of certiorari, Spencer does not develop his due process argument regarding overbreadth, but in briefing, he clarifies that his assertion that the circuit court exceeded its jurisdiction when it placed overbroad restrictions on the speech of non-parties without due process. It is unnecessary to address overbreadth as due process violations in this case. Our decision is governed by the free speech and void for vagueness analysis above. Okay, so they went over that. Now they're going to talk about sealing the case. Finally, we address the circuit court's decision to seal the case. Spencer contends that the community has the right to know what its government does in a public court proceeding. Yes, they do. He cites Arkansas Code Anointed Section 1610-105, which provides the sittings of every court shall be public, and every person may freely attend the sitting of every court. Here, after the court's order was entered, the case filings were removed from public view. See footnote 4. This court has recognized that an accused may assert his constitutional right to a public trial by arguing that exclusion of the news, media, and public violates that right. Yeah, he wants a public trial. He has a right to it. The inherent authority to seal parts of court files is tempered by the requirement that the request to seal part of the file must be particularized, that there must be some good cause for sealing part of the file, such as a trade secret, and that it should be in effect for only so long as it's necessary to protect the specified interest. Yeah. Like sealing of like medical records, that the court should seal those. And then, everything should be released besides those certain sealed things to the public. Like information that is not regarding the public doesn't have to be shared. You don't need to know the addresses or phone numbers of any of these people. That has nothing to do with what the public needs to know. You can't just seal them away from people forever. And that's the part of the Owens v. Eckerd case and all that, where Laura Owens wants her stuff sealed. And it's like, no. And the only reason we know medical stuff is because her attorney put that out there. Because the court wasn't going to allow any of that to be disseminated. And we didn't get that from the courts. We got it from her very own attorney that put it out there for the public. And she also put it out there for everybody to know in that case. But they're saying here, you can't just seal everything. You can only seal things for a certain thing, and then eventually a lot of those things should be unsealed. Not only are there written records inaccessible to the public, but also the briefings and statements from counsel at oral arguments indicate that Lonoke County Circuit Court's courtroom was at least partially closed to the public during Spencer's arraignment. Although it appears the Circuit Court intends to close further proceedings to the public, we caution the court from doing so without an evidentiary basis and adherence to the required constitutional analysis set out in Waller v. Georgia. And then they cite some other ones. It says the right to public trial is one of the most important safeguards in the prosecution of a person accused of a crime. Yeah, to make sure people are not being railroaded. You can't be like, oh, nobody's allowed in here except for us. Grand juries do that to get indictments, but you do not do that when you're trying to take somebody's liberty and life away. Conclusion. The Circuit Court's gag order is far too broad and too restrictive of speech protected by the First Amendment and Article 2, Section 6 of the Arkansas Constitution. It is also impermissibly vague. Further, the order was entered without requiring or without the requisite findings discussed above and woefully without factual basis. Therefore, we hold that the Circuit Court's order constitutes a plain, manifest, clear, and gross abuse of discretion for which there is no other adequate remedy. Accordingly, we issue a writ of certiorari and vacate the order. By this ruling, we do not foreclose the possibility that after an evidentiary hearing, the Circuit Court may issue a subsequent gag order narrowly tailored to specific factual findings supported by the record. However, we emphasize that a gag order should be a last resort, not a first impulse. Petition for writ of certiorari granted, writ issued, Circuit Court's gag order vacated. Wood, Womack, and Highland and Brawny J.J. concur. So Rhonda K. Wood, a concurring justice, says Aaron Spencer argues that judicial gag order violates both the United States Constitution and Arkansas Constitution. He is correct that it violates Arkansas Constitution. I write separately because as a matter of the state primacy doctrine, I believe we should resolve the case under the Arkansas Constitution before resorting to application of the United States Constitution. The test adopted by the majority is appropriate to apply under the Arkansas Constitution, as explained below. There are strong reasons to strike the state's constitutional law in cases like this one. First, our role as stewards of the Arkansas Constitution is best honored by examining and interpreting it instead of the U.S. Constitution. There is underdevelopment of many state constitutional issues, and we do Arkansans a disservice by avoiding the Arkansas Constitution to focus on the federal one. Yeah. Because if Arkansas has it in there, state by state, the state can handle it. Now, if the state didn't have it, then you can go bother the U.S. Supreme Court. But she's saying, this is a part of our state's constitution. You know this is wrong. We can handle this here, and you don't need to go any further. The U.S. Supreme Court is really busy with other stuff, and each individual state's Supreme Court can handle these things, such as this. So footnotes are some cases, and it says our system of dual sovereigns now comes with dual protections against overreaching state and local laws. American lawyers and judges would do well to pay attention to the liberty and property protections in federal and state constitutions, and the reason why the state guarantees often offer a promising source of protection. So this is an extra checks and balance that we have. The Arkansas Supreme Court is there to make sure that the circuit courts and the district courts and the superior courts are doing what they're supposed to do. And then we have the U.S. Supreme Court that is making sure that everybody else is doing what they're supposed to be doing. And then we go higher and higher. In State v. Bradbury, writing, nowhere is the need greater than in the field of state constitutional laws, where we are asked often to confront questions that have already been decided under the national constitution. And they cite some other footnotes, but we'll do that once we get to that page. When states cede to the federal, it creates the possibility of states being a mere row of shadows. In fact, we encourage litigants to raise Arkansas's constitutional arguments, and we should respond accordingly and address those raised arguments when appropriate. This is especially true in the area of the law where the United States Supreme Court has yet to set a clear standard. We are addressing gag orders issued in Arkansas courts, and our test should not be subjected to the uncertainty of federal laws when we can base it on state law grounds. So you are violating things that are state laws. We don't even need to go into the federal because it is on a basic level here. Why not settle it for Arkansas now and interpret our Constitution as giving additional free speech protection to our citizens? I fully join the majority's test because it's supported under the originalist interpretation of the Arkansas Constitution. I like that. Hey, we are here. We are doing our jobs too. You don't have to go above us. We can handle it right here. And props to the Arkansas Supreme Court for handling this and having the best interest of their Arkansasians. I don't know what they're called. All right. Text and history. When we interpret a constitutional provision, we begin with the text but determine its plain and ordinary meaning by examining it in light of its history. See footnote 3. It is well accepted that we look beyond the words, but also as to their public meaning at the time in history. We may also compare prior versions of our Constitution to interpret its meanings. All right, let's go look at these footnotes. The other one says may look to history of the times of enactment of constitutional provision to determine its meanings. Another one says when engaging in constitutional construction and interpretation, the court looks to the history of the constitutional provision. And stating a slavish following of federal precedent would render this court's opinions merely a mirror image of the federal jurisprudence. Okay. A. The free speech and the free press provisions of the Arkansas Constitution protection in the Arkansas Constitution of freedom of speech and of the press date back to the first Arkansas Constitution, which was adopted in 1836. So Arkansas has had this stuff since 1836. Article 2 provided as follows, Section 7. The printing press shall be free to every person, and no law shall ever be made to restrain the rights thereof. The free communication of thoughts and opinions is one of the invaluable rights of a man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty. Section 8. In prosecutions for the publication of papers investigating the official conduct or officers or men in public capacity, or whether the matter published is proper for the public information, the truth thereof may be given in evidence. And in all indictments for libels, the jury shall have the right to determine the law and the facts. This language is common to other early state constitutions dating back to at least the 1790s. See footnote 6. Says, as of 1871, the constitutions of 24 states, not counting Arkansas, contained one or more of these phrases in their provisions of freedom of speech and of the press. Okay. Contrast this with the First Amendment to the Constitution of the United States. Congress shall make no law abridging the freedom of speech or the press. This highlights that states choose to use different language from the federal constitutions and that they were understood at the time to retain and protect the freedom of speech and of the press inherent in natural law as developed in common law. See footnote 7, which says, see search such and such. Arkansas adopted subsequent constitutions, yet these provisions remained virtually unchanged until the Fourth Arkansas Constitution was adopted in 1868. There, the language was moved, and the discussion of the prosecutions for libel was incorporated into the section of the freedom of speech and press. The language was overhauled, and that became our current Article 2, Section 8. Or Section 6, sorry, see footnote 8. The noticeable change between the 1868 and the 1874 Constitution is the removal of the word speak from the second sentence, such that the former, all persons may freely speak, write, and publish, become all persons may freely write and publish. Okay, liberty of the press and speech, libel. Because libel is written. The liberty of the press shall forever remain inviolate. The free communication of thoughts and opinions is one of the invaluable rights of man, and all persons may freely write and publish their sentiments on all subjects, being responsible for the abuse of such right. In all criminal prosecutions for libel, the truth may be given in evidence to the jury. And if it shall appear to the jury that the matter charged as libelous is true and was published with good motives and for justifiable ends, the party charged shall be acquitted. So if things people are writing about are true and there are good motives behind it, you will be acquitted. Shall be. Not maybe, nothing. Shall be acquitted. Emphasis added. In its current form, the Arkansas provision is quite different from its federal counterpart, which allows us to interpret it differently. Analysis and conclusion of this. Next, we evaluate the text in its historical context. Early on, our courts recognized that free speech rights must be interpreted by more than a simple textualist manner, and then we look to the history surrounding it. The main purpose of such constitutional provisions is to prevent all such previous restraints upon publications as had been practiced by other governments, and they do not prevent the subsequent punishment of such as may be deemed contrary to the public welfare. See footnote 9. Patterson versus Colorado. Our constitutional provisions that the free communications of thoughts and opinions is one of the invaluable rights of man, and all persons may freely write and publish their sentiments on all subjects. It's a clear reference to national or natural law. See footnote 10. Americans typically viewed natural rights as aspects of natural liberty that governments should help protect against private interference through tort law, property law, and so forth, and that government themselves should restrain only to promote the public good, and only so long as people or their representatives consented. Judge Campbell, Natural Rights, and the First Amendment, 2017. Now, where did it go? Oh, it is certainly broader than the federal language, and communication necessarily is inclusive word choice. The grammatical structure and phrasing of this sentence sets forth very broad, strong protection for the free communication, writing, and publishing of ideas, all persons and all subjects. We then further to look to what was understood as acceptable limits in common law near the adoption of our Constitution. As this is a common phrase in state constitutions, courts and commentators alike have opined on its meaning. See footnote 11. Cooley, supernote 6 at 466, we understand liberty of speech and of the press to imply not only the liberty to publish, but complete immunity from legal censure and punishment for the publication, so long as it is not harmful in its character, when tested by such standards as the law affords. For those standards, we must look to the common law rules which were in force when the constitutional guarantees are established and in reference to which they have been adopted. It is certainly broader than the federal language and communication necessarily in its inclusive word choice. Oh, wait, we already read that. Okay. In 1804, the Pennsylvania Supreme Court explained it in this way: every citizen may freely speak, write, or print on any subject, but is accountable for the abuse of that privilege. There shall be no licenses of the press. Publish as you please, in the first instance without control, but you are answerable both to the community and the individual if you proceed to unwarrantable lengths. Footnote 12, they cite case. All the footnotes here just cite cases. The historical understanding of text that freedom to communicate was extensive but still limited by the common law is bolstered by our case law from that period. In Neal v. State, a lawyer was held in contempt of court for writing and placing a note on the circuit judge's office door accusing the judge of being a base and corrupt man. The court reversed, holding that we had the right derived from the common law to punish for contempt, but there were no contempt in the matter at hand because the note did not attack judge's official conduct. He just gave his opinion on what he thought. He was base and corrupt. You're allowed to say that. It's your opinion. He's not lying about conduct that the judge did. Anything. Then the state versus Morrill, this court upheld a contempt charge where the defendant published a paper claiming the judge in a case had taken bribes. This court considered whether the freedom of press precluded the contempt order and found it did not. So, somebody writes a paper claiming the judge in the case had taken bribes. And they said that it shouldn't be a contempt. So it says any citizen has the right to publish the proceedings and decisions of this court, and if he deemed it necessary for the public good to comment upon them freely, discuss their correctness, the fitness or unfitness of judges for their stations, and the fidelity which they perform important public trusts reposed in them. But he has no right to attempt by defamatory publications to degrade the tribunal, destroy public confidence in it, and dispose the community to disregard the set at naught its order, judgments, and decrees. Such publications are an abuse of the liberty of the press and tend to sap the very foundation of good order and well-being in society by obstructing the course of justice. Okay, so that one, the person crossed the line. I'm guessing because you don't have any evidence to show that a judge is doing this. You're just writing this with ill will. You have no good intention in saying this. You don't have anything to back it up. You're just mad at your court's decision, and so you claim that. I think it would be different if there was actually proof that the judge was taking bribes, but in that case, it doesn't sound like there was. In other words, one of the key limitations on freedom of speech and of the press was the court's inherent ability to protect the administration of justice. Thomas Cooley, the most prominent commentator on the state's constitutions during the mid-19th century, put it this way: except so far as those guarantees relate to the mode of trial and are designed to secure to every accused person the right to be judged by the opinion of a jury upon the criminality of his act. Their purpose was evidently based to protect parties in the free publication of matters or public concern, to secure their right to free discussion of public events and public measures, and to enable every citizen at the time to bring the government and any persons in authority to the bar of public opinions by any just criticisms upon their conduct in the exercise of authority when the people have conferred upon them. See footnote 17. That's just citing Cooley and where you can find that. Cooley made plain that strong protection for freedom of speech and publication, like those included in the Arkansas Constitution, nevertheless do not diminish the court's ability to administer justice and ensure defendants receive fair trials. This allows me to reach the conclusion that the gag orders are constitutionally under Arkansas Constitution. Saying this is why they have the right to do it, is because these gag orders are under this Constitution. Okay. Having determined that the gag orders are constitutional, I can apply the analysis to the facts before us. The gag order issued was prior restraint on speech of the broadest possible, unconnected with this case, or broadest possible order. It prohibits speech by parties, attorneys, and trial participants and third parties unconnected with the case, which did not exclude the media. Moreover, the circuit court failed to make any finding of fact that there was sufficient threat for such a broad prior restraint. Footnote says media was not particularly targeted by the gag order, yet it arguably was covered by it. The Arkansas Constitution closely aligns freedom of speech and press, and it stands to reason that we all should as well. Okay. Our Constitution does not support prior restraints on speech and publication absent extreme circumstances. Perhaps if a circuit court were to find such a threat of material prejudice to the proceedings, it may be appropriate for the court to take action, which there is none. As discussed above, Article 2, Section 6 of the Arkansas Constitution generally prohibits prior restraint on speech and publication and provides the strongest possible protection for the free communication of thoughts and opinions. This protection is broader than the provided by the federal Constitution. Footnote 19. Multiple state Supreme Courts have similar language in their respective state constitutions, having interpreted those clauses to generally provide broader protection for freedom of speech and press than the First Amendment of the United States Constitution. It says Pennsylvania's Constitution states the free communication of thoughts and opinions is one invaluable rights to man and every citizen freely speak, write, and print on any subject, being responsible for abuse of that liberty. So if you write, speak, say, whatever, you, as that person doing those things, are responsible if you abuse that process. Interpreting the California Constitution's free speech clause, every person may freely speak, write, and publish his or her sentiments on all subjects, being responsible for the abuse of their rights. or this right, as more definitive and inclusive than the First Amendment of the United States Constitution. Colorado tradition of ensuring a broader limited liberty of speech is long. For more than a century, this court has held that Article 2, Section 10 provides greater protection of free speech than does the First Amendment. Washington recognized that the concept of free speech in the Washington Constitution, which states that every person may freely speak, write, and publish on all subjects, being responsible for the abuse of rights, is interpreted more broadly than the federal Constitution. So they're saying that while you have protections in the United States Constitution at a federal level, the states give you more protection than even the United States. Your individual states protect you more on free speech than even the U.S. as a whole. So when you have the U.S. and your state backing your First Amendment right, you're really protected unless you do something really bad. Like you lie. Knowingly lie. Slander, libel. But the truth is a defense in the First Amendment. Like, you're not going to get punished for saying something that's the truth. Even though somebody may think it's harassment, you have the right to say your sentiments and opinions on things that you are being truthful about. Yet, a close examination of the text and history shows its protection is not unlimited. Consistent with the common law at the time of adoption of Article 2, Section 6 does not prevent the court from limiting speech to ensure the proper administration of justice. This test adopted by majority for issuing judicial gag orders are designed to maximize the freedom of speech and press and are narrowly tailored to achieve that goal. As the majority's tests are consistent with the original meaning of the Arkansas Constitution, I agree with their creation, but I would adopt them under the Arkansas Constitution. I concur in the judgment. Now we have Nicholas Brawny, Justice concurring. Public officials aren't immune from public criticism, judges and prosecutors included. Massachusetts, you need to learn this. Because the circuit court's gag order violates that principle, I join the majority's opinion granting the writ and vacating that order. But that sweeping order is only one part of a troubling pattern of attempts to shield this case from the public view, beginning with a non-public arraignment and ending with a handwritten note sealing the entire case from public view. We cannot allow that pattern to continue unchecked. So I'd invoke this court's superintending authority and resign this matter to a new circuit court judge. Anything less suggests that what happens so far is within acceptable range of disagreement or administration, and it isn't. Brawny ain't playing around. Mr. Nicholas. He is like, I don't even think you should be on this case. A new judge needs to be assigned to this case. Because you are definitely not being fair. You're not doing constitutional things. You're not upholding our laws. You're trying to create your own laws. And that's just not how we roll. Begin with a gag order itself. On its face, that order targets broad swath of people, barring them from expressing an opinion or making any comment about whether the evidence tends to establish guilt or innocence of the defendant. Worse, the order itself was sealed, raising serious concerns about selective enforcement. And it doesn't explain why such extreme remedies were warranted. Yeah, basically she's like, it's this way because I said so. I don't need any reasons. I'm the judge. I can do whatever I want, except you can't. Mm-mm. Instead, just declaring it would help ensure all the parties get a fair trial. Nor did the circuit court explain why it extended the gag order beyond what even the state thought was appropriate, broadening it to cover the defendant's family and even more significantly, sealing the entire case. On the contraire, the circuit court entered that order just 6 minutes after the clerk docketed the defendant's 19-page opposition to state's motion. So barely enough time to make a pot of coffee. That to me sounds like she did not read it because I mean, I guess you can read 19 pages in 6 minutes. Maybe. If you're like Ian Runkle, he can read really quickly. Um, that doesn't sound like they even read it. They were like, I don't give a fuck what the defendant says. This is my court, and I make the rules. That approach cannot be squared with the First Amendment, and it underscores that the gag order wasn't a last resort, but an unconstitutional impulse. We cannot have those. We cannot have unconstitutional impulses, people. I wish his opinion was first, because, man, I like his opinion. Context suggests why. The same circuit court that issued the gag order here also granted Michael Fossler's release on bail. It's that decision, which the defendant's lawyers called a decision to release a predator, quote unquote, who repeatedly violated the defendant's child on a low bond, that set off a chain of events that led to the fatal confrontation that's the subject of this case. And it's the criticism that the state claimed and the circuit court effectively concluded justified gagging the defendant, his lawyers, and others. This sequence raises serious concerns. Indeed, if openness enhances the appearance of fairness to essential to the public's confidence in the system, then secrecy has the opposite effect. It erodes trust. Yeah, they don't like that they gave somebody a low bond and let them out when they shouldn't have. And that predator went and did things again while out on bail. And now that person is dead. And the reason they don't like that and they don't want anybody to talk about that is because the blood is on their hands. Because had they not let him out, none of this would have happened. He would have not gone and taken that child again. But he did. And people, to me, have to start being harder on these predators. I don't care if it's their first time. They don't need a slap on the wrist. They need some mental help. They need jail. They need not to be around children. Personally, I think they should, things like this, especially to children, should be the same thing as murder. That's just my opinion, though. The effort to shield these proceedings from public view also didn't begin with the gag order. It started with the circuit court decision to arraign the defendant away from public view. Yeah, we're going to arraign the defendant and in secrecy as well. And even setting aside the potential constitutional concerns raised by non-public arraignment, that decision highlights the order on review here isn't isolated problem. Yeah, you've done a bunch of things that are not okay constitutionally. You are violating Aaron Spencer's constitutional rights, due process, and all of it. 1986 case discussing two-part test for determining whether First Amendment right to access criminal proceeding attaches. 1. William Blackstone, Commentaries 132, confinement of the person by secretly hurrying them to jail, where his suffering are unknown or forgotten. To me, that goes in line with the Richard Allen case and what they tried to do over there in Indiana. So many cases right now that are being highlighted because of things that the judicial system is doing. Sometimes we have crazy defendants and stuff, and we cover those too. But we also need to make sure that the justice system that we are supposed to entrust to hold these people accountable are doing what they're supposed to be doing. Because if they're not, then people get away with stuff over and over and over again, and things escalate even further. Last page of this opinion. Um, so, they're forgotten is a less public, a less striking, and therefore a more dangerous engine of arbitrary government. Yeah, we do not do things in secret. Judicial systems are not a secret society. Rather, it suggests a star chamber like atmosphere. We cannot allow that to continue. No, we cannot. Ultimately, judges and prosecutors enjoy no greater immunity from criticism than other persons or institutions. They cite some case, said, nor should they. Public vigilantes serve us well, or public vigilance, not vigilantes, serves us well. For the knowledge that every criminal trial is subject to contemporaneous review in the form of public opinion is an effective restraint on possible abuse of judicial power. You cannot do that. Just because you are embarrassed and you don't like being, you know, you don't like being scrutinized. Oh, well, when you took this job, you knew that that was going to happen and you have to deal with it. If you don't like it, it's not the job for you. Citing more cases, under our system of government, the primary check against prosecutorial abuse is a political one. Instead, justice should not only be done, but it should manifestly and undoubtedly be seen to be done. Yeah. Because if you're doing what you're supposed to do, nobody can do anything about it if you're doing your job. I mean, they can still say they don't like you, but I mean, most defendants, if they lose, or families or people that support them are not going to like you. But can they say that you're doing anything that's unconstitutional is different. If you're following the law, let them rant. They can say what they want. So I join the majority's decision granting the writ of vacating the gag order, but I would go a step forward further. The repeated attempts to veil these proceedings in secrecy can only breed ignorance and distrust of the courts and suspicion concerning the competency and impartiality of the entire criminal justice system. Remedying that danger warrants strong medicine, and I'd apply it. So Womack and Highland, JJ concur, and then they cite other people for the appellant and the appellee. And so that is their thoughts and opinions, and they're like, no. And we do not think that you should be on the judge on this case because this isn't just one wrong move. This is move after move after move. And you are trying to railroad this man. He was not getting due process, and justice was not being served. And they may think Michael Fossler is the victim because he was the one killed. I personally say the victim in all of this is Aaron Spencer's daughter. And I think Aaron Spencer was doing probably what any parent would do based on what I know right now. I don't know what could come out that could change that, but as of right now, if what he says is true, I do not think he should be charged. Do y'all agree? So this is what brought the case to the public and got more eyes on it, which I'm sure the judge loved. And so we need to understand how we got here. So next we will be covering who Michael Fossler is and then going into the rest of the case through the court filings. Please like this video, subscribe, turn your notification bells on so that you get updates. You can also follow me on Twitter at Loud Little Ducky, where I post when I'm going live. Because if YouTube doesn't send you a notification, maybe Twitter will, about everything that I do over here on YouTube as well. And I hope to see you in the next video discussing this case and others.